Welcome back to New Money. This evening we're talking estate planning. My guests, Harry Joffe and Giselle Gould. If you'd like to call, our number is 011-280-3899. My email is brian@bdtelevision.co.za. Harry, let's just talk about one of the issues with trusts, and that's poorly administered trusts, where the individual is actually in control of their trust. We talk about cleaning that up. We talk about making changes, making sure resolutions are passed, and there are meetings, and that you're not absolutely controlling your trust. How do you make a delinquent trust good?
Yes, Brian, as we were talking before the show, that's one of the very complicated areas of law. So you can look at British cases, you can look at Channel Island cases, you can look at South African cases. It's an issue that gets discussed often. You know, you've had a trust that hasn't been properly run, now you want to start running it properly. Does that cure the defect, first of all, for what you've done in the past, particularly in respect of creditors and ex-spouses? And then how do you clean it up going forward? Now, in South Africa, we've had a lot of cases on trust the last year or two. We had a case last week, Miller versus Miller, which was a divorce case. Trust was dragged in. And that's the first thing the ex-spouse claims, that the trust wasn't run properly, meetings weren't held, minutes weren't minuted. And we've had another case, Van Zyl versus Kay, which was a creditor case. And again, the same thing, that the admin wasn't done properly. Now, I mean, some people take this too far. You can't assume just because minutes weren't done and resolutions weren't passed that the trust is a sham and will always be pierced. That's not a given in law. So the fact that the minutes weren't done is an indication to the court, and the court might then look further in a divorce case to see if there are other areas where the trust can be pierced. But if your trust hasn't been set up properly at all and there was no intention to set up a trust, then the court would say the trust is a sham, which means the trust never ever existed, and that hasn't been done yet in our law. So, you know, all these issues of trusts, it's such a fascinating aspect to discover, because it's still new law all the time, and it's still not finally decided. This Miller versus Miller and Van Zyl versus Kay refer back to articles, and they go into great detail. And again, it's not 100% certain in law. You know, it's not cut and dried yet. So I can't say this is the answer, or this is not the answer.
But better to do something just to leave it, and just leave it as it is. I mean, people don't realize the importance of having trustees, and not you and your wife being the sole trustees.
Correct.
Let me just take an email from Arthur, because it relates very much. He's just sent an email. He says, he's from Port Elizabeth. He says, with an umbrella trust, what are the costs involved? How safe are the investments? And what are the returns, and who does the investments? So that's three questions in one. How safe is it?
I think also because the umbrella trusts that have been run in the industry, the proceeds used to come from retirement funds. And therefore, often the administrators of those umbrella trusts would follow the governance rules of a retirement fund, because trustees would obviously look for that. So you'd find that you have your regulation 28 in terms of the investments, you have your 13B in terms of the administration of those accounts, and breaking that down, it simply means that there's certain checks and balances that needs to be in place for the administration as well as for the investments. And investments, obviously considering that those were mainly used for minors under age 18, is generally more conservative, and your tenure would be limited. Therefore, in those instances, you know, it would be significantly more conservative than you'd either have in a retirement fund or a high net worth trust.
Giselle, in my experience, when I've seen trusts, and I've seen particularly trusts set for minors, I think trustees take far too conservative approach. You've got young children, 5 or 6, even under 10, not going to inherit that money till maybe even into their 20s, and trustees are shying away from equities.
Yeah, I think two things, just to go back on the cost issue. On average, the cost of running an umbrella trust for a minor would be in the region of 2% per annum, including the investments. So I think that's fairly reasonable. But sorry, the next question was?
I'm talking about being too conservative. Yeah.
Yes, and I think also markets have changed, and we cannot afford to necessarily have that conservative approach any longer. And a lot of the trust administrators and boards of trustees are stepping up and actually taking more risky investments, because you need to have decent returns on these things as well. And in a lot of cases, in our cases, these people are dependent on that return and income on a daily basis. So it's not a long-term saving, it's something that they need here and now. And therefore, the investments need to be riskier so you can have a better performance, and you need to be able to pay that out monthly and or annually, you know, where you have educational expenses.
And Brian, sorry, I mean, just to defend our retirement fund trustees a little bit, you know, a job of a trustee is a very difficult one. There's very onerous responsibilities on a trustee, and the Trust Property Control Act is very strict, and the court cases are very strict. Now, you as a trustee have to watch that money more carefully than you watch your own money. So you can understand when you're dealing on the behalf of a kid. I know you as an investment person think it's ridiculous, but a trustee will be very careful that that money doesn't be squandered. Because the kid turns 18 and now the kid can come and sue the trustee because they didn't look after the money properly. So you know, it's a very careful road they've got to walk.
But Harry, you talk about riskier assets. If you're investing in growth assets over a 10 or 12 years' time, the risk is inflation. And we know inflation is here to stay. And you know, if we talk about 12 years, the rule of 72, that means that an inflation rate of 6%, money will halve in 12 years.
Exactly. No,
and 8% is going to halve in 9 years. So if you don't take growth assets into the portfolio, I think there's more liability on a trustee for acting inappropriately, particularly if you take the lifespan of that trust and the potential delivery. But let me just take an email from Hazel in Morningside. She asked an interesting one, and people don't realize this. She says, when does a power of attorney become invalid, and is it better to form a trust rather than to apply for curatorship?
Well, okay, I mean, that's a great question. It's almost like a plant, Brian, because a power of attorney in South African common law ends the minute your mental facilities go. The minute you aren't mentally capable of revoking that power of attorney, the power of attorney is not valid. And then, of course, the question comes back, that's the whole reason normally why you create the power of attorney, because you aren't able to look after your own affairs. Not in our common law. So the trust should be created, but if you're going to create a trust, you've got to do it before you lose your facilities. Because, of course, once you've lost your mental capacity to make a decision, who's going to pass the assets over to the trust? You need a curator then. And there's a fascinating court case out about 2 months ago on a third-party case where an individual was severely brain damaged, big third-party payout, and the attorney and the advisor set up a trust, put the money in the trust. And the judge got involved and said that's a breach of the law. You've got no right to create a trust without a curator being appointed first, and the curator looking after the money and deciding what to do. And the judge sent it to the Law Society. He was so angry. So it's a fascinating question because that's this court case now.
But Harry, most people act with a power of attorney.
Correct.
Whether the individual is capable or not.
Because they don't know and they don't check.
And people that they're dealing with don't even know that themselves, because they see this, they have this power, the people have the power of attorney, but they don't realize that they really can't act.
But in law, that's wrong. In law, that's wrong. The minute they see a power of attorney and they see it's an older person, they should check. Because that older person is not in control, they can't act on that power of attorney. And then you have to get a curator. There's no other way in law to look after those affairs.
Well, you can call us on 011-280-3899. Got an email from Jeremy in Somerset West. He says, this is interesting, with disability premiums no longer tax deductible, it's not really an estate plan, and the proceeds tax-free, what happened to individuals who are receiving a disability payment and have done so for some years? Will the future payment be tax-free?
Okay, great question again. As current law stands, from 1 March 2015, when the law changes, no deductibility for any premiums, and all proceeds from a disability payout are tax-free, new or in claim already. Now, of course, there's a problem with that, because it's great for taxpayers, but those individuals that have been claiming disability for the last few years, there's a whole actuarial book and a whole actuarial assumption that a good part of them will go back to work eventually. It's not permanent disability. Now, you make these payouts tax-free, and suddenly they're getting a 40% increase in effect on their disability payment. They're not going to go back to work. And that's an issue that the insurance industry has raised with Treasury, and they're looking at it. But to be fair, that's not the law. The law says any payout from a disability fund post 1 March 2015, in claim or new, is free of tax.
That's an unbelievable. Email from Dave in Park. He says, if I take advice on estate planning, include my accountant, lawyer, and tax practitioner, and it turns out that some of the advice is incorrect, but I followed it, are there any penalties that can be imposed on me? So here's an individual getting advice, talking about tax planning, talking about estate planning, worrying about the possibility that maybe there could be some penalties imposed. I don't know what
could be tax penalties, for example, if things go wrong. I mean, unfortunately, Brian, that's a risk you take. If you follow your advisors, it's your name on that tax return and you're the one responsible. So SARS comes after anyone, they'll come after you. They might come after the tax practitioner in a different guise, but they'll come after you as a taxpayer. And then, of course, you would have to go after your professional advisors in a professional negligence claim if that was applicable. But that's a blunt answer, that you are the taxpayer, you are responsible, and you'll carry the can at the end.
Okay, well, we're going to take a break. You can call me on 011-280-3899. Stay tuned, we'll be back shortly.